indulgence to reach the matter and take up matter. Family pension related matters. Family pension is not disturbed because of the pendency of the return. I am for the respondent.
When do you want?
My lord, on in the next week, my lord. Next week on
Matter, what is the subject matter?
family pension, my lord.
Matter which year?
Matter of 24, my lord. Or my lord, let me take up in September 11, my lord. September 11.
Okay.
Leave.
My lord, with extreme apology. My senior colleague, Mr. S. Biswas, on the other side.
Mr. Biswas?
Yes, the other side.
Yes,
Item number 4.
Yes.
when you want.
Well, any day, because part-time matters and top of the list matters are fixed in the report, both shifts. It's only
What
the
is-
contractual employees whether they are getting the material.
Matter came up before your lordship earlier also
Earlier also.
hard,
It can be part
but
of it
thereafter it has not come, my lord.
for a long time. It is hard in length.
Yes.
It's hard in length.
When do you want?
Except second and third, my lord. Or second,
My
third
lord,
and fifth.
second week of
Lordship fixed it.
second week of
It can be
September.
disposed of. Lordship heard the matter also.
15 matter, difficult to adjourn. Sri S. Bonik, Learned Council for the petitioner, prays for a short accommodation. Para also heard Sri S. C. Biswas, Learned Council for respond number 5. Para. List on.
Find this.
List on 5th of September.
5th of September. Obliged.
May I please, Your Lordship?
Yes.
Lordship, prior to move an unlisted matter today, my lord, the urgency is that matter pertains to appointment of office assistant in the District Legal Service Authority. And petitioner's application was rejected on the ground of non-enclosure of employment accent certificate, whereas the petitioner has submitted it. So, my lord, the Viva has been scheduled on today, tomorrow, and day after tomorrow. So, maybe taken up today, my lord. Otherwise, you would not be able to appear in the Viva, my lord.
When did you come to know about this?
My lord, on 22nd of August, on 27th of August, we made a representation before the chairman, my lord.
Difficult. Today, second half, we have some doubts whether we'll be sitting. We bring it in the first half.
My
Have
lord,
you filed or not?
my lord, yes, we have filed it.
Today?
We'll try to bring it, my lord.
Today you have filed?
Yes. We'll try to bring it on the first of my lord.
Okay, try to bring it.
Much
Who's
obliged.
on the other side?
Standing Council, District Legal Service Authority, my lord. I will inform,
Please inform them.
I will inform.
Doubt we can have it tomorrow in that case. I think tomorrow would be better. It will be listed also. Move it tomorrow.
My lord,
Move it tomorrow.
much obliged.
Please, back to mention item 6, my lord. Some personal difficulty, my lord, today with the consent of the other side.
Yes. When do you want? Yeah, for the State Bank.
No, previous statement.
Yes.
Yep.
On a request made by Sri A.K. Sahiwala, Learned Council for the respondent State Bank of India, matter is adjourned to be listed on
24th, your lord. 24th.
24th September. Why?
As your lord.
On 11th of September.
Well.
11th.
May it please your lordship, I beg to mention item number 5. This matter is infructuous, my lord.
Okay. Ms. B. Das, Learned Council for the petitioner has submitted that by flux of time, the matter has become infructuous. Para. Also heard State Council, D. Bora. State Council. Matter is accordingly dismissed as infructuous. Okay.
May
Mr.
it please-
Sikdar, your name,
My lord.
you're there in 3 and 4?
Yes,
AR Sikdar 3 and 4, huh? Infructuous.
my lord.
May it please your lordship. Lordship, I pray for listing of 2 writ petitions, my lord. This matter pertains to, my lord, retirement benefits of the petitioner, my lord. And meanwhile, my lord, one of the petitioners have expired. So we have preferred interlock IA, my lord, for substitution of the name of the
Okay,
petitioner.
we'll have it next Wednesday.
Next,
Wednesday.
yes, ma'am. Oh,
That will be on, I think, 4th.
4th is a
On,
holiday.
not 4th. Then we'll have it on 5th, 6th, or you can have it on 2nd. Second, it may not be possible. So let it have it on 6.
6, my lord, yes.
6.
I'm open.
May I please, Lordship, Lordship, I beg to mention for listing, Lordship. Matter pertaining to promotion, matter post of junior assistant, Lordship.
Matter which year?
Lordship, 2024, Lordship.
24 promotion matter, no out of turn listing. Sorry. Yes, next.
May please, Your Lordship, with the consent of the Honorable Body, I'd like to mention item number 9 of the daily list.
Yes.
Your Lordship may kindly fix it after 2 weeks.
Yeah, for the petitioner,
Yes, Lordship.
on a request made on behalf of the petitioner, matter is adjourned to be listed after 2 weeks. Yes. এই এচিটো নালাগে, মোৰ ঠাণ্ডা লাগি আছে, গা ভাল নহয়।
Lordship, kindly pass on. Time being, Lordship.
What is the matter, Mr. Boro?
If confirmation of probation, Lordship. We have to pray for time being, Mr. Mohanto is also on legs, Lordship of court number.
Won't that be appearing?
Yes, he will be.
Okay, after some time.
Last occasion, what you directed to obtain instruction.
Regarding,
Implementation of
ACP scheme.
CPC scheme fix.
you've got the instructions?
That CPC scheme was implemented in the Sonic School in 1998, my lord. My lord, in 4th March 1998, in the Sonic School, my lord. After that, my lord, some persons approached the honorable court, my lord, and honorable court passed some order, my lord. On the basis of that order, my lord, again some notification has been issued by the Sonic School Authority, my lord. But my lord, I apologize to say, my lord, I read that, my lord, notification, but somehow I missed the notification in the late, my lord, in the last night. Whole night I have been searching for that notification. Kindly take the matter at 2 o'clock, 2 o'clock, my lord.
2 o'clock, this court may not sit.
Then, my lord, after some time, because I read the whole.
Whole matter, to a 12 matter, you should
Yes, my lord.
give
No, no,
priority to these matters. It was heard also at some length, I think.
Yes.
my lord. Already hard, my lord, because I read that similar situation, similar cases, my lord.
Will,
After 1 hour, my lord, the whole night I have been searching, my lord. Till now, I didn't get that, my lord.
no, you.
Give me 1 hour, my lord.
No, you have it on, we'll fix a date, on the Tuesday next.
Yes.
Tuesday.
Must
You
come
take
back,
your
my lord.
time, but Tuesday, today it may not be possible.
Yes, my lord, that's why. my lord.
Though certain instructions have been received by Ms. A. Gayan Leonard CGC, comma, it is prayed that some more instructions would be required for Sapera, considering that this matter is of the year 2012, comma, a short accommodation is granted and granted by directing listing of this matter on 3rd September.
Must have been.
3rd,
Yes, ma'am. Must have been.
3/9.
Obliged.
My lord, I was, my lord, a permanent, my lord, employee of Assam Rifles. And I completed, my lord, 15 years, 9 months and 3 days till to the date of discharge. Ultimately, my lord, during the tenure of service, there are 4 different allegations were made against me. As a result of which,
You are working as what?
as cook.
Cook.
And ultimately, my lord, they imposed penalty by your rigorous imprisonment against each of the matter charge allegation. Now they are saying there was some summary proceeding. But of course, my lord, that summary proceeding would not do or cannot validate their subsequent action. They said, since there are 4 different red ink entries in the dossier, therefore, it is a case of discharge. Therefore, my lord, Supreme Court, because my lord, I don't want to trouble your lordship, I will refer to 2 decisions of the my lord Supreme Court as well as our High Court. Latest decision. And whatever decision they have referred in their affidavit of opposition, all are, my lord, I think, my lord, overruled. Supreme Court says, and in the line of Supreme Court, our High Court says, code identity cannot be the Lakshman Rekha. Exactly, they use that particular term. You are supposed to hold an inquiry because you brought certain allegation, and on the basis of allegation, you have imposed penalty, punishment, rigorous imprisonment. Subsequently, on the basis of same allegation, you issued show cause notice, seeking reply. I submitted reply. You abruptly, my lord, came to the conclusion that we are not satisfied and accordingly discharged. Therefore, my lord, I will pose a question for myself, and to answer this question, whether code writing entry can be the basis or guiding factor for discharging an employee from service. And to that extent, my lord, if your lordship decide this question, then, my lord, I need to go into any other aspect. And to that extent, my lord, I will refer certain decision. This is the only question, because they took a stand in their affidavit that it is not mandatory. And what is the observation?
What is not mandatory?
My lord, holding of inquiry. And once there is a code writing entry, they can straightway exercise their power and discharge. This is the only question involved in this case, my lord. Good, yeah. My lord, may I just now refer to certain decision, my lord? And otherwise, it will lessen the burden of the court to decide this question if the court looks into this decision. Because they don't have any other stand. And whatever decision they have taken, and I'll refer to in their affidavit, I think, my lord, these decisions were not at the moment in force. My lord, I will refer to last decision first, my lord. That is our High Court decision.
Name?
My lord, Durgesh Kumar Meena versus Union of India. And this decision is relied on, my lord, decision number 2. And this is a decision of the Supreme Court, my lord, Virendra Kumar Dubey.
Yes, which part?
My lord. There is by Honorable Justice Al Jameen, my lord, in 2024, 26 to 2024, date of delivering the judgment.
Yes.
My lord, Roshi, may I come skip over if the fact is same case. My lord, 4, 3, and my lord, allegations, my lord, unauthorized absence. Here you also, my lord, unauthorized absence 3. And next one is the, my lord, loss of government property, such as identity card. Here in this case, I am going to refer, our 4th allegation is the same allegation. My lord, para 6, I'm just referring para 6, 11, 12, 13,
Yes.
14, 15, and of course, my lord, 17. I'll read, my lord, everything will be clear.
Yes, please read.
My lord, first of all, I'll read para 5. My lord, it will be, my lord, facilitate the court to understand whether charges are identical. The respondent have filed, para 5. Respondent have filed the counter affidavit, and in para 2, it is stated as under. The brief history of the case as stated above. So-and-so, Kumar so-and-so was enrolled. My lord, may I just ask my junior, my lord, I said, I problem. Para 5. Một tôi chẳng hạn, para 5, 6. Para 5, 6. 11, 42. Para 5.
Para 5, Your Lordship. The respondent have filed counter affidavit in paragraph number 2. It is stated as under that the brief history of the case is stated as follows. Durgesh Kumar Meena was enrolled in the Assam Rifle on 19/10/2009 and was posted to 7 Assam Rifle on 17/9/2010. After completion of his basic military training at Assam Rifle Training Center and School, the petitioner was tried summarily on 4 occasions between 2017-19 for act omission on his part, and he was awarded 4 red ink entries in his service those years. Detail of the offences committed by the petitioner and punishment red ink entries awarded to him are as under. 3 days rigorous imprisonment in Assam Rifle custody on 22/9/17 under Section 35 of Assam Rifle Act 2006 for an offence of intoxication. Copy of summary trial proceeding attached as Annexure 1 series. 7 days rigorous imprisonment in Assam Rifle custody on 3/10/2017 under Section 26B of the Assam Rifle Act 2006 for an offence of without sufficient cause overstaying leave granted to him. Total period of absence is 11 days. 7 days rigorous imprisonment in Assam Rifle custody on 5/2/18 under Section 26B of the Assam Rifle Act 2006 for an offence of without sufficient cause overstaying leave granted to him. Total period of absence is 35 days. D. 28 days rigorous imprisonment in Assam Rifle custody and 14 days pay fine on 19/8/19 under Section 41B of Assam Rifle Act 2006 for an offence of lodging by neglect identity card, the property of government issued to him for his use. Para 6. Learned counsel for the petitioner submits that the discharge of the petitioner due to the poor red ink entries in his service those years was done in a mechanical manner, and the gravity of the poor red ink entries was not considered by the competent authority while the discharge order dated 23/5/2020 was issued. He also submits that the Honorable Supreme Court in the case of Birendra Kumar Dubey versus Chief of Army Staff and other reported in 2016 2 SSC 6-7
And here, my lord, in the compilation, that decision number 2.
has held that poor red ink entries simply pushes the individual concerned into a gray area where he can be considered for discharge. However, thus because he qualifies for such discharge does not mean that he must necessarily suffer the fate. In the present case, it is submitted that the poor red ink entries in the service dossier of the petitioner are not serious, and therefore the impugn order dated 23/5/2020 deserves to be interfered with. Para 8. Mr. G. Pegu, learned CGC, appearing on behalf of the respondent, on the other hand, submits that the petitioner is serving under the 7 Assam Rifle, which is a disciplined force, and therefore the poor red ink entries would automatically mean that the service of petitioner is no more required, as he is an incorrigible offender, and accordingly, the impugn order dated 23/5/20 was issued. He also submits that the petitioner was so caused before issuance of the impugn order, and after consideration of his reply, discharge order was issued. Para 9. I have considered the submission made by learned counsel for the parties. Para 10. The poor red ink entries enter into the service dossier of the petitioner has already been extracted herein above. Para 11. This court has also considered the advisory issued by the Ministry of Home Affairs, Director General Assam Rifle Shillong on 15/7/21. The relevant portion of the advisory is quoted herein below.
This is the latest, my lord, latest circular.
Keeping in view the judgment and order dated 16 October 2015, the competent authorities at all levels must take cognizance of the following during application of mine while exercising the disciplinary power for discharging an individual from service on incurring 4 ink entries. A. The case of each individual on incurring 4 ink entries should be examined for its own merit, depending upon the nature and gravity of the offense and the aggravating circumstances under which these 4 offenses were committed by the individual. B. Discharge from the service on incurring 4 ink entries is not a mechanical process. The termination of service is warranted on merit of a particular case, and each case has to be examined in detail based on facts and circumstances. C. The total service rendered by an individual should be considered, and wherever possible, individuals should be given an opportunity to complete the qualifying service for the grant of pension. D. Before discharging an individual from service for incurring 4 ink entries, adequate opportunity should be provided to the individual for his defense by way of convening an appropriate inquiry. Para 12. A perusal of the advisory issued by the Ministry of Home Affairs, Directorate General of Assam Rifle would clearly indicate that incurring 4 ink entries should be examined on its own merit, depending upon the nature and gravity of the offense and the aggravating circumstances under which these offenses were committed by individual, and the discharge from service on incurring 4 ink entries is not a mechanical process. Para 13. On consideration of 4 ink entries awarded to the petitioner, it is seen that he underwent 3 days rigorous imprisonment for the offense of intoxication on 22/9/17, 7 days rigorous imprisonment on 30/10/17 for the offense of overstaying the leave granted to him, 7 days rigorous imprisonment on 5/2/18 for the offense of overstaying the leave granted to him, and 28 days rigorous imprisonment on 19 and 19 for lodging his identity card. Assuming that the past 3 red ink entries are serious in nature, this court is of the considered opinion that the 4th red ink entry is a matter which needs consideration for the respondents in as much as lodging of the identity card may be beyond the control of the petitioner.
Same is the argument, my lord.
In case of Birendra Kumar Dubey Supra, the Supreme Court has held as under. The government has, as rightly mentioned by the learned counsel for the appellant, stipulated not only a show-cause notice, which is an indispensable part of the requirement of the rule, but also an impartial inquiry into the allegation against him, in which he is entitled to an adequate opportunity of putting up his defense and adducing evidence in support thereof. More importantly, certain inbuilt safeguard against discharge from service based on 4 ink entries have also been prescribed. The first and foremost is an unequivocal declaration that mere award of 4 ink entries to an individual does not make his discharge mandatory. This implies that 4 ink entries is not some kind of Lakshman Rekha, which if crossed, would by itself render the individual concerned undesirable or unworthy of retention in the post. Award of 4 ink entries simply pushes the individual concerned into a gray area where he can be considered for discharge. But just because he qualifies for such discharge does not mean that he must necessarily suffer death fate. It is one thing to qualify for consideration and an entirely different thing to be found fit for discharge. 4 ink entries in that sense take the individual closer to discharge but does not push him over. It is axiomatic that the commanding officer is, even after the award of such entries, required to consider the nature of the offense for which such entries have been awarded and other aspects made relevant by the government in the procedure it has prescribed. This court has also considered the communication dated 51/2020, by which the reply given by the petitioner was held to be found not satisfactory. On consideration of same, it appears that the communication dated 15/1/2020 was issued in a mechanical manner without giving any due consideration to gravity of the 4 ink entries entered into the service dossier of the petitioner. Further, no reason have been assigned in a communication dated 15/1/2020 to indicate as to why the reply given by the petitioner has been found to be not satisfactory. On consideration of the same, this court is of the considered opinion that discharge of the petitioner from 7 Assam Rifle by the order dated 23/5/2020 is a harsh
Okay.
and without.
Yes.
My lord, Now, Lordship, kindly see at page 10 of the writ petition. And I have given a chart showing that what are the imprisonment imposed on me, my lord, against each of the allegations. At page 10 of the writ petition. Only, my lord, difference is that there is a charge of intoxication, but in my case, there is allegation of 3 unauthorized absence, and 4th one is loss of government property, as that was in that particular case. And now these are the 4 different allegations, and they imposed rigorous imprisonment. Now, Lordship, kindly see. Yeah. Index.
Okay.
I'm sorry, madam. क्या करता है तुमको? My lord, index, my lord. Shoppers reply at page 44. And thereafter, my lord, I submitted my reply. Then by the annexure 8 of at page 45, impugnment order was issued.
Just a minute, please.
Page 45. No.
Page.
Page 45. May I read, madam? Whereas there is impugnment order dated 27/9/2014 discharge order. Whereas it is considered that the conduct of so-and-so, name so-and-so, which led him getting 4 red ink entries is such as to render his service under his further retention in the public service undesirable, being an incorrigible offender, and having shown no improvement during his service. And whereas so-and-so was afforded an opportunity to show cause against the proposed action at so-and-so, and whereas so-and-so submitted his reply so-and-so of show cause notice dated so-and-so issued by so-and-so, the same was considered in terms of ROI 499 and was found unsatisfactory by the competent authority. Same is the, my lord, decision taken, whatever reply I submitted, my lord, in reply to, in response to show cause notice, is found to be not satisfactory. And this court observed is in a mechanical, my lord, assessment of the gravity of the offence, etc. And Supreme Court says that cannot be the basis. And once I incurred 4 different red ink entries, that cannot be the basis, so as to exercise power for discharging the service. Therefore, in view of that decision, our High Court, which is of 2024, relied on decision of Supreme Court, my junior has already pointed out, my lord, the relevant paragraph of Supreme Court judgment, Virendras. Therefore, my lord, lordship will, my lord, accept this decision to be the basis and set aside the discharge order. If that question is decided, my lord, in my favor, I need to go into any other aspect. Now, whether it can be the basis or something more is required to be done. Can they straightway say there is no necessity to hold any further inquiry? Because you incurred 4 different rat in and
What is the prescription of law?
prescription law is that, my lord,
If there are 4 entries, what is the
prescription law is that, my lord, they can access power. They can access power for discharge. But it was observed by the court, it cannot be because there is a gray area. So by the 4th, my lord, allegation is concerned, do I have any control? I made specific, my lord, specific statement before the authority. I feel, my lord, ill. And I can't say, my lord, when I lost the bags. Immediately
No,
therefore,
leave aside the 4th red entry. What about the first 1, 2, 3?
1, 2,
Third-
3 also, my lord, says then it will be 3 writing entry. If fourth one goes, then there will remain 3 writing entry.
But losing an identity card by a member of the discipline force, is it proper?
My lord, I could wrongly rightly, or I could observe, relying on the decision of Supreme Court. He does not have any control over it. It requires some more inquiry. And report was submitted by police that we made an investigation inquiry and we found, my lord, incident took place, occurrence took place, but we could not trace out the, my lord, articles. Therefore, my lord, in that situation,
Here in this case, what was the article? It was the identity badge.
identity badge, passbook, and my lord, liquor license, and my canteen license. These are the, my lord, allegation made, and if her 4th one goes, my lord, then it will, my lord, 3 will remain. And 3 cannot be the basis for arriving at the conclusion that I am incorrigible offender. Lordship is absolutely right, my lord. Lordship may go, even may not agree, may disagree with the decision of my lord, Court of Ordinary Jurisdiction. But at the same time, I say that, my lord, since that decision is entirely relied on Supreme Court decision. Therefore, my
Okay,
lord,
Mr. Adhikari.
Yes, my lord. My lord, my friend has relied on that Supreme Court judgment, my lord. Of 2015, my lord, I have the copy of the judgment, my lord. There, it was a case of no inquiry at all. Whatsoever, my lord, no inquiry was held. Can also be kindly come to have a look at para 18 of the judgment, Supreme Court judgment. No inquiry at all, my lord. Here, my lord, I will show. My lord, inquiry was held, summary trial was held, my lord. So there is a difference, distinction between the 2 cases, my lord.
inquiry there clearly.
Para 18 of the judgment.
There was no inquiry. Yes, he's correct.
Lordship can come to my affidavit. From annexure, my lord. But NHS 1, page 71. is the impugn order, my lord. My senior friend has already read it, my lord. So I don't, I will not trouble a lordship on that. My lord, what is the-
27/9 order.
Yes, my lord, this is the impugn order.
Yes.
Next is the, my lord, PPO, pension has been paid to him. Gratuity, pension, leave encashment, my lord, has been paid to him. He is receiving the pension now.
So he is getting the pension.
Yes, he's getting the,
Or in the other case, there was a consideration that
yes,
while taking into the advisory by the ministry,
Yeah.
that not to deprive of the pensionary
Yeah.
benefits. He is getting the pension.
Yeah. well, that your lordship will find it annexed to at page 72. And my lord, regarding leave encashment and my lord, the gratuity, your lordship will find it, my lord, page 3,
Oh, pension is complete.
PPO, my lord. And he has also received, my lord, gratuity amount of rupees 1,58,000. The leave encashment amount of rupees 1,25,119. That your lordship will find it page 2 of my affidavit. Next is the crime report for the first offense. Next, annexure is the crime report, page 73. My lord, he was remanded to, he was awarded punishment of for 10 days. Imprisonment for 10 days. The next 74.
What is your age, Mr. Purgasto?
My lord,
What is your age?
age is, my lord, as per the writ petition,
You are 43
43,
in the year 2015.
15,
Now you are around 52.
52. 43, at page 35. Now, lottery is right page, say 52.
Then your lordship may kindly come to page 75 of my affidavit, my lord.
73 is the crime report.
Yes, crime report. 74 is also crime report. For my lord, unauthorized absence. First is for 10 hours, 30 minutes. Second is for 19 hours, 30 minutes. The third charge, my lord,
52.
is 52 days.
days.
50 days. Lordship will find the charge sheet at page 76.
Yes.
The next page, my lord, the proceeding of hearing, my lord, he was heard on the charge, my lord,
Can I check one?
page apna rule,
Yes, I do.
connected to numbering. Page 77 is the recording, hearing, recorded. Here also will find that he declined to, he declined to adduce evidence or cross-examine the witnesses, my lord. You will find, lordship will find there are two witnesses in this proceedings, my lord. One is Lusai and another is Tilendra Bora. Then your lordship may kindly come to.
This was prior to the reading entry.
Mine. The third rate, it was on the third rate entry, my lord. Well, after, on, my lord, incurring the 3 rate entry, my lord, he was warned that if you incur another rate entry, you may be deterred.
Inquiry means, what, I'm sorry to interrupt, my lord. Inquiry means inquiry after 4 rat ink entry. Because there was summary inquiry in respect to other allegation, and on the basis of that, ultimately they impose RI. That cannot be constituted to be an inquiry, my lord. But I understand, my lord. Because court
No,
observed.
see, Mr. Purkasta, the imposition of reading entry is not the subject matter of challenge.
My lord.
You are only aggrieved by the order of discharge
My lord.
after four reading entries.
My lord.
You say that you are not given adequate opportunity,
My lord.
and simply basing on 4 reading entries, you
My
cannot.
lord.
That is your case.
My lord case. And whether they are otherwise obligated to hold any further inquiry in conformity with, my lord, natural justice, but giving me an opportunity to discuss the
We are
allegation.
trying to extract from Mr. Adhikari, what was the notice given to you?
Yes, my lord. Then lordship may kindly come to the notice, my lord. Yes, that is at page, my lord, 85. After the third rate entry, my lord,
Hmm.
this notice was sent to him was given served on him on 10th of May 2014. You were enrolled, my lord, so and so. These are the three charges, my lord, against him.
What is warning?
Warning. This is a warning to him, my lord.
Hmm.
The review and lordship will find on the next page, my lord. It is clear from above that in spite of being advised, I mean, many times to improve your conduct, you did not show any improvement. You are hereby warned to be more careful in your conduct if you enter fourth reading entry in your service document. Then action will be taken to discharge you from service under section 11(2) of Assam Rifle Act 2006 and para 17, Rule
Yes.
17 and 25
Yes.
of 2010 rules.
Thereafter,
Thereafter, my lord, that incident occurred, my lord. He lost his I card along with some other document. And again, my lord, a charge sheet was issued to him.
where is that?
Your lordship will find at page 81.
81.
I'm sorry, madam, these are not added in a proper manner, in proper order. Page 81.
I think 80. 80 is the offense report.
Yes, 81 is the charge sheet.
Okay.
No, he was heard on the charge, madam.
Hmm.
Then lordship may kindly come again, my lord. I'm very sorry, madam. These are not arranged in a proper order. Now the court of inquiry was held, madam. Lordship will find from page 95 onwards.
This 82 is the proceeding of the fourth reading entry. 82?
82, yes, my lord.
Yes.
It was after the third charge, my lord.
No, after the fourth charge.
After the fourth.
Fourth charge. Fourth charge sheet is 2612
Yes.
and this proceeding is of 2712.
Yes,
For the fourth. And there's a reference of fourth allegation.
Yes.
then my lord, your lordship will find from page 95 onwards, the court of inquiry was held. So for the fourth charge was concerned, my lord, regarding the loss of I card.
Hmm.
Witness number one, my lord, the petitioner himself was witness number one, my lord. He was questioned. Page 96, the lordship will find witness number one, Binu D. Next page, my lord, witness number two, Surinder Singh.
Okay.
But may I point out one thing, I mean, both the witnesses, my lord, so far as they have stated that his conduct otherwise was good. The opinion of the court, your lordship will find at page 101.
Thereafter, what has happened?
So thereafter, my lord, he was discharged from the.
Isn't there a requirement to give
Yes,
him a
Focus,
notice?
yes, Focus
Where
was
is
sent to him.
Focus? Where?
Focus was sent to him, my lord.
Where? Page?
So just a minute.
That you have. Before discharge of.
Before discharge was ordered here.
Focus was.
This is what I'm saying. So 30, it is in the writ petition, my lord. Annexure, six, page 42. Annexure 6, page 42.
Prior to discharge.
Obviously, prior to discharge.
Yeah.
That is what is required.
The paragraph says, my lord, it is clear from above, that in spite of having been advised many times to improve your conduct, you did not show any improvement even after incurring rating increase. You have thus become an incorrigible offender. Keeping this in view, it has become essential to initiate action against you in terms of para 5 of ROI 1 of 2004, section 11(2) of Assam Rifle Act 2006 and Rule 17 and 25 of Assam Rifle Rules 2010. You should submit your reply to Focus notice within 30 days of its receipt. My lord, he submitted his reply. Next page, you will find that. Next page is not annexure 7. Is this reply to the so-called.
But 20 years of pensionable service, that has been taken care of.
That was that.
That has been taken care of. Your only anxiety was that let me complete 20 years of pensionable service. And Mr. Adhikari has
Yes.
made a statement that you have been paid pension and that is not in dispute.
In case of discharge, my lord, I am entitled. It is not because of that mercy. It is a statutory right. to
No.
grant the pension.
You, in your reply at page
Well-
44,
My lord.
you have said that let me at least complete 20 years of the pensionable service.
Yes.
That means you are under an apprehension that your
Yes.
pension may not be paid. But that apprehension has been put to rest.
Yes, sir.
I would have got my lord better pension. Had I been allowed to continue my lord up to 20 years.
No, no, that's a different matter. For 20 years of pensionable service.
That's right.
That is over.
Well, I raised a question, my lord, even assuming that, my lord, what they have referred is nothing but a state of inquiry. Whether on the basis of the statement recorded, can it be, my lord, sufficient to allow the conclusion? And my lord, what is the observation made? He does not have any control. You inquire, my lord, against the fourth, my lord, allegation. And whether it is because of my negligence, whether part is the elements of a negligence, my lord.
No, Mr. Purkastha, we cannot go back to the aspect of the fourth red entry, which
Hello.
was of the year 2013. That is not the
Hello.
subject matter.
My lord.
To if you want to argue that the fourth red inquiry has not been done in a proper manner,
Right.
you should, then you have to challenge that. You are challenging the discharge order.
That's right.
Let us see your prayer.
Your lordship is right, my lord. That part was,
That has attained finality.
that's
Let us
right.
see the provisions of law, Mr. Adhikari.
But if I say that the passage of arriving at a conclusion is not justified, because you had an inquiry, you arrived at a conclusion on the basis of the statements recorded by you, whether these statements are at all sufficient to prove the, my lord, element of negligence. Because you cannot bring any charge unless and until there is some
So
negligence.
so
on
we
my part.
cannot go back to the respect
Right.
unless it's a matter of challenge.
Lordship can exercise, my lord, promotive power.
No, why?
Lordship has got a lot
The
of,
discharge is based on four
I-
red entries.
if the my lord, illegality is apparent on the face of the record, Lordship may exercise, no, rejudication is absolutely unprotected.
In absence of any challenge.
Yes,
Not
Lordship
even a
can.
semblance of challenge.
Lordship can, my lord. Lordship can.
Why should
Because
you?
the court exists to dispense with justice. Even assuming that there is lapse on the part of the petitioner in not challenging
To
particular.
exercise those powers. In absence of any semblance of challenge, if there was even an indication, that is not even the subject matter. Let us see this statutory provision.
Yes, my lord, lordship may
Yes.
kindly come to page 88, my, we have annexed the rules, my lord, rule 17.
88.
Page 88 of my affidavit.
Yes.
Yes, my lord, Rule 17, termination of service. Authorized. Authority is specified in the headings of columns 3 to 6 of the
This is
table.
part of what?
Apart of the affidavit filed by
No, this is what rules?
rules, Assam Labor Rules 2010.
No, we'll have the rules, some referral rules from some.
I have to prove my,
That's it only. No, not policemen, it's some rifles. Item, serial number, the section.
Rule is my lord, Rule 17.
You can't act all, rules can't lie.
Well, I have the rule.
Rule 17.
Yes. Rule 17.
Okay, okay, this is the rule which you have quoted,
Yes, I have,
and at page 88.
yes.
Okay, okay, rule 17. What does it say?
Authority specified in the headings of the column 3 to 6 of the table given below shall be competent to dismiss, revoke, discharge, retire, or release a member of the post specified in the columns on the grounds stated in the corresponding entries in column 2 in accordance with the procedure laid down in this chapter. Any power conferred by this rule or any provisions of the chapter on any of the aforesaid authorities may also be exercised by.
No, we
any-
are not on this, Mr. Adhikari. We are on the procedure which empowers you
Yes.
to discharge when there are 4 number of red entries.
Well, now, Lordship, may kindly come to page 90.
90?
Yes, 90. Now, this is rule 25. Because, my lord, yeah, the order, imprint order, your lordship has seen, my lord. It is on the powers conferred by para 5 of ROI 1 of 2004. My lord, by chapter 8 regulation,
Yes, show us this.
yes. Yes. My lord, that your lordship will find in the imprint order itself.
No, we have seen, we have understood the provision.
25.
Rule 25, my lord. Page 90.
Yes.
Rule 25 may kindly be seen. Termination of service of enrolled persons on the grounds of unsuitability. Where commandant is satisfied that an enrolled person is unsuitable to retain in service. But as the person had incurred a poor rating entry, my lord, so he has become unsuitable to be retained in service, my lord. The enrolled person,
Where is that provision that 4 red entries will make him unsaid? You cannot retain him in service. Where is 27?
20,
Where is 27? Read 27 from your book.
well, 27 is resignation, my lord. 25 is termination of service of an enrolled person on the ground of unsuitability.
Let us go back to the impugned order. What has it
Yes,
referred?
yes.
11 to
Page 45 of the writ petition.
Please read.
Para 4, my lord, now therefore in exercise of powers conferred on me under records of his instructions 1/2004, para 5 by chapter 8 rule 24 of Assam Rifles Manual read with section 11(2) of Assam Rifles Act 2006 and rule 17 and 25 of Assam Rifles Rule 2010. The undersigned hereby discharges the state number so and so, name so and so from Assam Rifles being incorrigible offender.
Let us
soldier
see
with
this
effect-
provision. We want to see this provision.
But, this provision ROI, my lord, ROI 1 of 2004.
What is Rule 24 of Assam Rifles Manual?
Lordship, may kindly, my lord, I have another judgment of apex court, my lord, in Balwanti's case, though, my lord, in para 20.4 of this Vijender Kumar Dubey's case, my lord, it has been discussed, it has been distinguished. So here, my lord, that para 5 has been discussed, my lord. We Lordship, may kindly have a look at this. Well, under that provision, my lord, the power is there. Para 8 may kindly listen.
This is দিবা না গরম হয়ে বলবো
The provision has been quoted. Second. Yes, it to hold, Balwant Singh to hold 2015.
What is Rule 24 of the Assam Rifles Manual?
23.
Rule 24 of the Assam Rifles Manual. You can have a look at the charge order of 27 September. It refers to certain provisions of the law.
But here, my lord.
Lordship has referred, my lord, Assam Service Manual.
No, you come to page 45. The discharge order.
Discharge. Yes, my lord.
Paragraph 4.
Para 4. Now, there also in exercise of power conferred on me under the record of office
Instruction
dated-
1. Paragraph 5. We want to have a look. What is this instruction?
Yes,
Then Rule 24 of the Assam Rifles Manual, read
Yes.
with Section 11(2) of the Act, read with Rule 17 and 25 of the Rules of
Yes.
2010. What are these?
Upper 24. বেলেগ কথা কি?
নেটত পাবা নেকি? এটা হ'ল Assam Rifles Manual, Rule 24. Assam Rifles Manual নে? Rules নহয়.
বেলেগ কথা নাই তাকে
Now, Mr. Adhikari, the argument which has been made by the petitioner that after 3 red entries, he is given a warning.
Yes,
So
sir.
there has to be some provision that if there is one more red entry, number 4, then he would be liable to be discharged.
Yes.
Where is that provision? I think it'll be available with you in the net or somewhere.
Yes, my lord.
Just read paragraph 4 again at page 45.
Yes, my lord.
We want these provisions of law.
Yes.
Page 45, discharge order,
Yes, ma'am.
paragraph 4.
RY
Out of first, we need ROI 1 of 24, 2004,
Yes.
paragraph 5.
Yes.
Then Rule 24 of the Assam Rifles Manual,
Yes, my lord.
read with section 11 to 11 rules and act we have.
Yes, sir.
What about the manual and the instruction?
But I asked for the manual one, they are not doing. So, my lord, how should we keep this matter as part of, let me be on.
No,
Monday,
not
my lord.
part, we're closing it. You give a copy of the thing to the court master. You search it and
Yes, yes.
have it list.
Document pick up the matter on Saturday.
No.
We'll check up.
No, Saturday I'm not.
Saturday we have a court martial.
Pension person. Yes, 5 has been quoted in this decision. ROA is there. Decision which you have referred.
Para five.
Yes, my lord, that's my.
Eight.
Balwant Singh,
Yes,
can you
para-
show,
Para 8. of the
para
judgment.
8, the 5 has been,
Yes.
section has been quoted.
Yes, my.
Got 4 or more red entries.
Yes.
Okay, Likha. Anything else, Mr. Purkasta?
My lord.
Anything else?
Regarding what, my lord?
Anything else you want to
Oh,
submit?
anything. Anything, my lord? Now they are saying, my lord, Balwant Singh is a distinguished.
I didn't know.
Oh, and to what
No, we are
extent?
not relying upon Balwant Singh. We are
Only
only
for that particular provision.
provision. 5 has been quoted.
Provision, my lord, for provision, I am also searching, my lord. What is the exact
It is
provision?
there. Say clause 5 ROI is there. Kindly show it to him.
Yes, yes. No.
Wait. That was replaced by my subsequent because there is a reference of 2000, my lord. In our High Court judgment, there is a reference that they have issued a fresh circular matter. I have pointed out. And in view of that matter, whether that will have any, my lord, role to play. Yes. That was, my lord, para 16 of our High Court judgment. There is a case of Durgesh. My lord was pleased to refer to, my lord, para 16, in para 16, on consideration of the same, court is of the considered opinion that paragraph 15, there is a reference from notification.
Yes, please
Yep.
read.
My lord, the court has also considered the communication dated 15/1/2020, by which the reply given by the petitioner was held to be found not satisfactory. On consideration of the same, it appears that the communication dated 15/1/2020 was issued in a mechanical manner without giving any due consideration to the gravity of force that enter into the service dossier of the petitioner. Further, no reason have been assigned in the communication dated 15/1/2020 to indicate as to why the reply given by the petitioner has not found to be not satisfactory. On consideration of the same, para 16, this court of the considered opinion that the discharge of the petitioner from 7th Assam Rifles by order dated 23/5/2020 is harsh and without considering the gravity of the offense involved in the matter. Therefore, I think, my lord, in 99, what they referred, that has been, my lord, modified and superseded by subsequent notification. And lordship, paragraph 11 of the judgment, there is a, my lord, discussion regarding, my lord, that notification. Then paragraph 11, I am reading, the court has also considered the advisory issued by the Ministry of Home Affairs, Directorate of General Assam Rifles, Shillong on 15/7/2021. The relevant portion of the advisory is put at here in below. Keeping in view the judgment and order at 15 October 2015, the competent authorities at all levels must take cognizance of the following during application of mine while exercising the disciplinary power.
The division bench of this court,
My lord.
which you are relying Balwant Singh, that has been,
Division
that
bench is
order has been interfered by the Honorable Supreme Court. It's the same case,
same case. Oh, that, I'm not aware.
same case.
Durgesh, Durgesh.
No, not Durgesh.
Balwant.
Durgesh is the.
Balwant.
Balwant.
Balwant is of my lord. It careful.
Here, it was interfered because the petition was dismissed with a single judge. It went in appeal.
Appeal it was allowed
Yes.
and Supreme Court has upheld the
Right, yes.
dismissal by the single judge.
But I am relying on Virendra. Virendra is relied on by our High Court in Durgesh Kumar.
Now, Virendra says that there was no semblance of any inquiry.
No,
Here,
yes.
you are given a notice.
Notice, my lord, regarding what? Regarding a court entry.
Not only fourth entry.
Yes,
No.
Even
Court
warning
entry.
after third entry.
13 they did not, they only, my
Let
lord.
us see the so-called notice at page 42.
Now, suppose notice there is a reference.
Sir,
But
there-
inquiry they refer to, whether that inquiry was in respect to
42.
other three
It is
allegations.
not on fourth red ink entry. It is on all four. After third, you are given warning, you did not correct yourself. Fourth red ink entry, not matter of challenge. Scope is very, very limited.
My lord,
Okay.
whether, my lord, the observation made by Virendra regarding, my lord, court allegation, that is loss of government property. Court observed that it is beyond his control.
You
whether
challenge
it's-
it, you challenge it, Mr.
My
Purgaster.
lord, that's Austria's.
You challenge it,
Austria's content.
that fourth red entry was not done in accordance with law. You did not have any control.
That's right.
Yes, Aleka. Please have a seat. The present petition under Article 226 of the Constitution of India has been filed challenging an order of discharge from service dated 27/9/2014. Full stop. The departmental appeal preferred by the petitioner has also been rejected on 28/10/2014. Para. As per the facts projected, but the petitioner was serving as a cook in the Assam Rifles. Full stop. While in service, he had faced 4 different proceedings wherein he was punished, and accordingly, there are 4 red ink entries, wrong, red ink entries. Thereafter, the petitioner was served with a so-called notice on 38/2014 as to why he should not be discharged. Full stop. The notice was responded to by the petitioner on 10/9/2014, whereafter the impugned order dated 27/9/2014 has been passed. Full stop. Para. I have heard Sri A.K. Purkastra, learned counsel for the petitioner. I have also heard Sri M.R. Adhikari, learned CGC. Full stop. The para. Sri Purkastra, the learned counsel, has submitted that so far as the 4th red entry is concerned, pertaining to loss of identity card and certain articles, no fault could have been attributed to the petitioner, and therefore the impugned order dated 27/9/2014 has been passed without jurisdiction. It is submitted that to exercise powers for discharge, comma, there is a requirement of having at least 4 red ink entries. Full stop. By drawing the attention of this court to a chart which has been put in paragraph 10 of the petition, the learned counsel has submitted that the first 3 charges were of unauthorized absence, which, according to the petitioner, is not of serious nature. Full stop. So far as the 4th charge is concerned, regarding loss of identity card and other materials, comma, it is submitted that the same could not have been a charge, as the petitioner had explained the matter by assigning cogent reasons. Full stop. It is submitted that on that particular date, comma, the petitioner was unwell while at Dimapur railway station and had fell unconscious, and in that event, comma, the items went missing. Full stop. The learned counsel has relied upon a decision of this court in Durgesh Kumar Meena, so and so. In the said case, wherein a similar challenge was made, this court had also relied upon the case of the Honorable Supreme Court in Virendra Kumar Dubey versus so and so, reported in 2016, 2 SCC 627. It is submitted that Mayor submitted that simply because of red ink entries, comma, the same would not mean that the only option of discharge is left. It is submitted that in the said case of Durgesh Supra, the discharge order was interfered with. Full stop. The learned counsel has also submitted that the past services of the petitioner was not taken into account before taking a decision to discharge him from service. He accordingly submits that the reliance has also been placed upon a decision of the division bench of this court in Balwan Singh versus Union of India, reported in 2011, 5 GLT 640. Full stop. In that case, comma, the Honorable Division Bench had interfered with the orders of discharge, orders of discharge. Para. The learned counsel for the petitioner accordingly submits that the impugned order dated 27/9/2014 be interfered with with a further direction to reinstate the petitioner in service. Full stop. It is pointed out that the petitioner still has a number of years left wherein he can render his service. Para. Per contra, comma, Sri M.R. Adhikari, Learned Counsel has submitted that so far as the 4 red entries are concerned, comma, there is no manner of any challenge to the same. Full stop. It is submitted that each of the red ink entries were made by following the due process of law. By referring to the affidavit in opposition filed on 10/3/2016, comma, the learned CGC has submitted that each of the 4 red ink entries were preceded by a due process of law whereby the petitioner was given adequate opportunity in accordance with the prescription of law. It is submitted that in any case, none of the 4 red ink entries are the subject matter of challenge. Full stop. It is submitted that after 3 red ink entries, comma, on 10/5/2014, the petitioner was given a specific warning not to indulge in any further activities which would entail a further red ink entry, in which case he would be discharged from service. However, comma, even after that, the 4th red ink entry had to be made on certain charge. Full stop. Para. As regards the case of Durges cited on behalf of the petitioner, comma, the learned CGC has submitted that the aforesaid case of Durges has taken into consideration the case law of the Honorable Supreme Court in Virendra Supra, full stop. By referring to the case of Virendra Supra, comma, the learned counsel for the respondent has submitted that in that case, there was no inquiry at all. And in that context, the observations were made. Full stop. The learned counsel has also informed this court that so far as the case of Balwant Singh Supra is concerned, the same was the subject matter of appeal before the Honorable Supreme Court, and the said appeal was allowed, and the discharge of the incumbent was upheld. This said decision is reported in 2015, 14 SCC 389. Para. The learned CGC accordingly submits that no. As regards the apprehension of as regards the apprehension expressed on behalf of the petitioner regarding non-receipt of pension, comma, the learned CGC has submitted that gratuity, pension, leave encashment, and all other benefits have been paid to the petitioner. Para. The learned CCC accordingly submits that the writ petition is liable to be dismissed as the same is without any merits. Para. The rival submissions have been duly considered. Para. The challenge in this petition is with regard to the discharge order dated 27/9/2014. Full stop. Though an argument has been sought to be developed that the aforesaid discharge order has been passed without jurisdiction, as the fourth red ink entry was done in an improper manner, this court has seen that there is no challenge to any of the any of the red ink entries or the procedure adopted. Full stop. Be that as it may, to dispel any doubts, this court has looked into the procedure adopted before making the red ink entries, which have been disclosed and annexed to the affidavit in opposition of the respondents. Full stop. Each of the red ink entries were preceded by the procedure laid down in law, and the petitioner was given adequate opportunity to defend himself. Full stop. In any case, as observed above, none of the procedure adopted or the action of making the red ink entries are the subject matter of challenge. Full stop. In that situation, this court cannot go back to the aspect of the legality of the procedure adopted for the red ink entries. Full stop. Para. The petitioner was admittedly issued a so-called notice on 30/8/2014 after the 4 red ink entries were given. Full stop. The said show cause notice was replied on 10/9/2014, and the primary concern of the petitioner was to allow him to serve at least 20 years of pensionable service so that he could get pension after his retirement. Full stop. However, a bare look at the discharge order dated 27/9/2014 would disclose that the petitioner was held to be entitled to pension and gratuity as admissible under the rules. Full stop. So far as the procedure adopted, this court has noted that under clause 5 of the Record Office Instruction 1 of 2004, the power is vested upon the authorities to discharge any members after who has got 4 or more red ink entries. Full stop. For ready reference, the aforesaid provision is extracted herein below. Is it Balwantor Supreme Court paragraph 8 the provision of the aforesaid instruction being clear and there being no apparent violation of the procedure laid down, this court is not in a position to accept the submission of the petitioner towards his challenge against the discharge order dated 27/9/2014, full stop. In view of the above, comma, the writ petition is dismissed. Okay. ইয়াৰ পৰা extract কৰিব লাগিব দেই কিবা কিবি। Okay.
Obliged, sir. I have done my according my ability.
এইখিনি তাতে হেৰি থৈ দিব হা এইমাত্ৰ হোৱাটো।
May I please your lordship?
Motion matter.
Yep.
Sangeet Neelam Bora. Yes, what is it?
My lord, the petitioner, my lord, was working as a senior administrative assistant in the Assam Public Service Commission. My lord.
Yes.
My lord, initially he joined in the year 2016 as a junior assistant, my lord, and thereafter he was promoted, my lord, in the year 2021. In the year 2022, my lord,
Yes.
there was an advertisement for the post of research assistant, my lord,
Yes.
a fresh advertisement,
Research assistant,
research assistant. My lord, he
2022.
applied,
Yes.
he applied, my lord, and he was selected and he was appointed as a research assistant. Now, my lord, because the rules provided, my lord, he also kept a lien, my lord, on his earlier post, my lord, that is as a senior administrative assistant, my lord. The post of research assistant, my lord, it provided for a probationary period of 1 year, my lord, subject to extension for another year, but not beyond that. And in the meantime, my lord, he had completed 2 years, my lord. After completion of 2 years, my lord, as a probationary, my lord, on 23rd of August, my lord, a letter was issued which is impugned before your lordship, my lord, by which he was reverted back to his original post, my lord, as a senior administrative assistant
When?
on 23/8/2024.
Yes.
He was reverted back, my lord. Now, my lord, the question of reversion, my lord, it occurs in the Assam Services Discipline and Appeal Rules, my lord, though it has not been held to be punitive in nature, my lord. Here, my lord, for the purpose of reversion, there has to be certain cause, my lord, for which he is found either to be unsatisfactory in service in the new post, or that he has done something, my lord, which was not acceptable, my lord, in the new post, or which he could have, my lord, he reverted, I could have understood, my lord. But here, my lord, reverting him back to the earlier post, because now he is not in a lien on that post at any point of time, because, my lord, after completion of 1 year, he had written to the commission that the lien on that, my lord, earlier post, my lord, that a senior administrative assistant may not be extended, because he could not have held 2 liens, my lord, on 2 posts, because now, when, my lord, that he has been appointed substantially in the post of research assistant, my lord, whatever lien is there, my lord, that lien will be there in that post, my lord. In 2 posts, there cannot be any lien, my lord. And because he has been reverted back in this manner, my lord, that is why he is before your lordship, my lord, that could not have been done, because in the earlier post now no longer exists so long he is concerned, my lord. He has been, my lord. So in my case, my lord, I have submitted before your lordship, my lord, even though there is no a particular letter of confirmation of his, my lord, service, my lord, on the end of the probation, my lord. My lord, because the probationary period, my lord, provided by the rules is only for a period of 1 year and thereafter to be extended for another 1 year. And he has completed, my lord, that 2 years of service, my lord. So it is a deemed, my lord, it is implied that he has been confirmed in that post, my lord. And now, my lord, if he is sought to be penalized, my lord, or, my lord, reverted back, my lord, that will amount to a punishment, and then the protections under article, my lord, 311 and 310 will come into play, my lord. And without, my lord, giving him at least, my lord, an opportunity to show cause or to, my lord, give him or hear him, my lord, he could not have been reverted back, my lord. This is my humble submission, and that is why
Yes,
we
Mr.
prepare lordship,
Bhanto.
my lord.
Your lordship kindly see. Your lordship kindly see the appointment letter,
Page
27. Page 20.
Please, I read it, my lord.
Yes.
Subject to the reversion without prior notice, without assigning any leave. Therefore, Sangeet Nilam Bora, senior assistant of the Assam Public Service Commission, is appointed temporarily as a research assistant in the office of the revised pay of 2020. Will be prime minister post with immediate effect. So, my lord, in it, appointment letter itself reflected, my lord. Your lordship kindly see, without, and now, my lord, his whole case is based on team conformity. But there in the rule, there is no provision for deemed conformity. In the rule only, my lord, confirmation is will 18 your lordship kindly. And my lord, his main argument is that, my lord, he is in revert back and it is a punishment. So 311 is, my lord, applicable in his.
No, no, that argument we may not accept. But what about, why did you revert him? Was his performance not up to the mark?
My lord, yes, my lord, that has to be, my lord.
No, where is it?
No,
Where
that
is it
that,
reflected?
my lord, in impure order, it cannot be reflected, my lord. That will be in the record, my lord. If it is there, it has to be recorded. And my lord, your
You
lordship,
get the records.
my lord.
You get the records. There has to be some decision
Yes,
to
yes, my
revert.
lord. Your
And
lordship
decision
kindly
has
see
to be
rule-
based on certain reasons.
Rule itself says, my lord. Your lordship kindly see rule 18.
Yes.
Rule 18,
Have you annexed that rule?
No, no, my lord.
he is not annexed.
The rules is here, my lord. I can-
Ah. Please read.
The confirmation of a provision who has completed his period of his satisfaction of the appointment authority shall be confirmed by the post. The satisfaction of the, my lord, that is the criterion. So that's why in the your lordship kindly see that in the order, and he also, my lord, applied for, my lord, cancel. He's not paid for any extension of his lien, my lord. He's a quasi lien, my lord. He was granted. Your lordship kindly see page 37, my lord. Page 37,
You get the records.
my lord.
You, the decision-making process you place it before us.
Yes, definitely, my lord.
That will-
File a explored affidavit, my lord. and next week,
Definite
my
may
lord.
not be required. If you want to file, but we'd like more interested in to know what is the decision-making process.
My lord. My lord.
Till then, I may be allowed to continue as a research
No,
assistant.
that order is already, my lord. Cannot be, my.
Why?
Why?
Heard. Sri G. Chaudhary, Learned Counsel, for the petitioner, who is aggrieved by an order dated 12/7/2022, whereby, no, not 12/7.
No, no.
What is the order?
2024.
23/8/2024. Where is the page?
Page, my lord,
38.
annexure K at page, my lord, 38.
Whereby whereby he has been
Oh, so nice.
reverted back to the original post of senior administrative assistant. Full stop. It is the case of the petitioner that while serving in the post of senior administrative assistant, comma, he was duly selected and appointed in the year 2022 to the post of research assistant, which was initially on a probation period for 1 year and extendable to 2 years. Full stop. The petitioners claim to have completed 2 years and without assigning any reasons, comma, he has been reverted by the impugned order. Full stop. Para. Sri T.J. Mohanta, Learned Senior Counsel for the APSC, has however submitted that the appointment order dated 12/7/2022 was itself conditional. Full stop. Be that as it may, comma, the decision-making process for reverting the petitioner is to be examined. Full stop. Para, let notice be issued, returnable on, we'll fix the date. On, can you have it on 11th?
My lord.
11th of September, 2024. Sri Sharma, P. Sharma, Learned Counsel, assisting Sri Mohanta, accepts notice on behalf of the respondents let extra copies be served upon him, upon her during the course of the day. Para? On receipt of the instructions and perusal thereof, this court would consider the interim prayer. Get the instructions
My lord.
and the records.
Today then I'll be hanging, my lord.
You join joining of the petitioner in the post of senior administrative assistant would be without prejudice to the rights and claims made in the petition.
My lord, let me allow to continue, my lord, as an assistant, my lord, without anything, my lord, just.
See the records.
My lord,
We'll
the
see the
law
records.
is also, my lord, if I may just place, my
We'll
lord.
see the records.
No, my lord, I may just place the law for a second, my lord. This is the constitutional based judgment, my lord, which says, my lord,
Not at this moment, Mr. Chaudhary.
my lord.
Until the
My
return
lord,
will date.
because, my lord, why should I be, my lord, subjected to, my lord, this sort of a, my lord?
Let us
stigmatic,
see
my lord?
what is there. We do not know
At
what is
least
there.
till then, my lord, if he doesn't have a reply, my lord, at least till then I may be protected. That is my humble submission, my lord. Kindly protect me till then, my lord.
Sorry. Let the records come. We said
Fine,
we'll
I-
consider.
I am mobile.
My lord, before my learned friend start, my lord, this matter was last listed in 2016. And I have even come to the court record to argue the case on the second copy. Second copy also, there is no second copy.
You take the copy from the court. Second copy is here.
Okay.
It will oblige you. When can you do?
My lord, can it
All
be on
matters.
the next Thursday? Next Thursday, I'll reconstruct the file by then.
Okay, you take help of this. Okay.
I would have given him, but
Oh.
there's only one copy with
Okay, what is the matter?
matter, your lordship, it's a disciplinary proceeding. The petitioner has been reduced to the lower time scale of pay. He has retired long back here.
Okay.
This is the fifth round of litigation, your
Okay,
lordship.
okay.
This petitioner has
Uh,
come out.
While Sri Y.S. Manan, learned counsel for the petitioner, is present, comma, Sri S.P. Sharma, learned counsel, appearing for the respondent board, prays for some time to reconstruct the records. Puts the para, considering that this case is of the year 2015. List
Next Friday, next Thursday, my lord.
list on Thursday next.
Fifth.
Here's another pen, Lucilla. Yeah.
Fifth.
লিখা পেন লৈছিলে ডাফ কিবা এটা এটা যে পাৰ্মানেণ্ট ইংকৰ পেন আনিছিলে ক'ত ক'ত আছে এইটো লগাই লিখি দিবা 6884 এইখন আগৰ কেছটোত থৈ দিম APSC Yes,
I have called.
yes.
11th. Here, this matter basically is with regard to the termination of the service of petitioner. This
Yeah, for the respondents.
for the three visas, basically.
2, 3, 4.
The petitioner, your lordship, will just give a gist of the facts of the matter. The petitioner was appointed as cleaner on 8/5/1986.
Cleaner.
Cleaner in the library and publication department of the Tea Research Association, Toklai, Jorhat. As a cleaner boy in 8/5/86. On 1/4/2006, your lord, he was promoted to grade AD1 within bracket 3. Most probably administrative 1, 3. And,
Yes.
and the issue actually happened from this, your lord. What has happened? On 1/6/2009, one Mr. Kailash Saikia instituted a complaint under section 138 of NI Act before the CJM Jorhat, which was registered as CR case number 191 of 2009. This is on the ground that he has availed some loan from Mr. Kailash Saikia and issued 2 checks which were dishonored. This is basically the issue here. Then, Your Lordship, on 10/6/2014, in between, Your Lordship, then nothing has happened. The matter before the CJM Jorhat continued. The petitioner was also working in the office. On 10/6/2014, the judgment was delivered in the complaint matter under 138 by the CJM, wherein the petitioner was sentenced to undergo simple imprisonment for 6 months and pay compensation of 2 lakhs.
Yes.
Then, Your Lordship, on 4/9/2014, the petitioner was arrested and remanded to judicial custody. And therefore, from that day, from 4/9/2014, the petitioner was absent from duty. So, in the, Your Lordship, the criminal case, the NI case, the petitioner preferred an appeal before the Sessions Court during the meanwhile, Your Lordship. I'll come to that later. On 15/10/2000, I'm just saying that on 15/10/2014, the Sessions Court admitted the appeal and granted bail to the petitioner. Then on 13/11/2014, the conviction was also stayed by
13,
the appellate court, that is the Sessions Court.
13/11.
13/11/2014.
Sentence was stayed.
Yes, it was. Now, Your Lordship, I'll just go back to 15/10/2014. In 15/10/2014, the respondent number 3 suspended the petitioner from service with effect from the date he was arrested, that is on 4/9/2014. There was, I'll come to there was on violation of certain clauses under the TRA service rule. I'll also produce the service rule for you. Then on 17/10/2014, that is within 2 days, sorry, respondent number 3 imposed the penalty of dismissal from service with effect from 4/9/2014, that is from the date of his arrest, on the basis of certain clauses of the TRA service rules, wherein it was stated that since he was guilty of the court order and therefore he was dismissed and directed to vacate the official quarter. This is basically the facts of the case. Petitioner thereafter preferred an appeal before the appellate authority of the TRA, and the appellate authority on Your Lordship 8/12/2014 just informed the petitioner that by an order that his termination is irrevocable, but he was given some more time to retain his quarter. That is good. In the appeal, Your Lordship, I will just point out this stay order of the court was also produced. The bail order as well as the stay order was produced.
Yes.
Again, the petitioner on 22/12/2014 preferred another representation, and that was also replied that his termination was irrevocable. And they again on 3/1/2015, the pleader's notice was also issued, and on the same thing, termination was irrevocable. Nothing, no, the reasons were given. My case will be on basically 2-3 points. Number one is the order of termination was issued without any input on the basis of the ground that he was convicted by the court. The second was with regard to the TRA rules, whether I violated any TRA rules or not. According to me, I have not violated. And the third point is, Your Lordship, that the case under the 138 of Negotiable Instrument Act does not constitute moral turpitude. If it does not constitute moral turpitude, there in that case, a person cannot be dismissed because it is not against the society. It's against a single. Some decisions are there. I'll come. So this is basically the overall matter here. I'll take your lordship to straight away to the judgment. Judgment also at annexure 2.
Page,
Just a minute. Annex- Hmm? Please. This is the judgment on delivered on 10/6/2014. I'll not read the judgment. We are not. I'll just read in page 33. Page 33. Operative part, just before the order, is just the paragraph. I'll read that paragraph once because of certain that not concerned, but I'll just read. Hence, I find your lordship has found that. Yes. Hence, find that the accused have a liability towards the complainant, and therefore the question of issuing the checks is in discharge of the liability does not arise. Therefore, I hold that the prosecution has failed to prove guilt of the accused beyond all reasonable doubt. Its points are accordingly answered in negative. So it was answered in negative, but what is the order, your lord? See, the accused's order is that accused is found guilty of offense under section 138 NIA. The accused is accordingly sentenced to undergo simple imprisonment for a period of 6 months, also liable fine of 220,000 in default 3 months. Apart from the sentence, the accused is entitled to pay compensation of 2 lakhs to the complainant. This is the order here. Now your lordship will kindly see the order of the sessions court in the appeal, that is at page 35.
just a minute, please.
35.
Just a minute.
Annex 3, page 35. Next. This is the order of 15/10/2004 of the Sessions Court. Here I'll just read the last paragraph at page 35. In the bail petition number so and so, dated so and so, filed on behalf of the accused appellant, I have heard learned counsel for the accused who has submitted that accused appellant is at present languishing in jail in connection with the above noted case, and counsel has therefore paid to allow the accused appellant to go on bail. Also heard so and so, learned counsel appearing on behalf of the respondent who has no objection if the accused appellant is Justin Dotto is enlarged on bail. In view of the above, I deem it fit to enlarge the accused. So bail was granted by this order, and then by the next order, that is page 37. This is 13/11/2014. Your lordship, at the penultimate paragraph, but the prayer of the accused appellant is allowed. The operation of the impugned judgment order passed in connection with CR case number 20 on the 130th of NI Act is hereby state till disposal of it. So that was also. Now your lordship will find the next page, page 38, annexure 5. This is the order of 15 October 2014. Prior to the, your lordship, the order of stay, but on the date of the order of bail. Here I'm just reading that. Further to our letter dated so and so, wherein you have been found guilty of misconduct in clause 20. Dated, no, I think I have to go through the initial order here, then it will be easier for you. That order your lordship will find at page 28. Page 20. Annexure 1. Lordship has got. Further to the charge sheet by number so and so issued your domestic inquiry. No, sorry, this is not the order. I'm sorry. No, the order is, this is the 15 October is the order, not the earlier. That is with regard to another matter. I'm sorry. Page 38. Page 30. Further to our letter number so and so dated so and so, wherein you have been found guilty of misconduct under clause 7.1. I'll give the copy of the clauses. 7.1, 7.2, 7.3.2, 7.7, 7.3.25, so and so, so and so, of PRI Service Rules Part 1 on conclusion of domestic inquiry for the charges leveled and proved against you by charges so and so violation of PRI rules till further notice. I'll keep this at the moment here, Your Lord. And I'll go to the appeal. Thereby suspended. This was the suspension order. Therefore, you are hereby suspended from service of the association with effect from 4th September 2004. So on the day from when he was arrested, he was suspended. On the grounds of violation of clause, these are the 3 clauses given of the TI. So this is the suspension. Now your lordship will kindly go to the next page. Lordship will mark the date of the order, that is 15 October 2014. And now your lordship will take up the impugn order, that is 17 October 2014, within 2 days. There's no disciplinary here. I'll just point. This refer to order number so and so dated 15/10/2014, suspended you from the service of the association with effect from 4th September for violation of so and so clauses. Further reference to the honorable court order dated so and so by case reference number so and so of NI Act, wherein you were found guilty of offense punishable under section 138 of NI Act and sentenced to imprisonment in jail, were arrested and challan to Jorhat jail by cinema so and so. As you have been found guilty by the honorable court order dated so and so, you have violated clause so and so, so and so, so and so. The management, in concurrence with the above, has decided to impose upon you the penalty of dismissal from service of the association with effect from 4th September 2014 under clause. So this is the dismissal order. Next, your lordship will kindly turn to the next page, page 40. This is the appeal which I have filed. Here, your lordship, I'll not read the whole appeal. At page paragraph 3, at page 41, I have given the specific ground that one Kailash can institute a false and frivolous case against the appellant so and so by CR number so and so without appreciating evidence at hand and without applying his judicious mind past the full sentence and judgment, thereby sentencing appellant delinquent, and the appellant delinquent thereby being aggrieved and not satisfied with the judgment and sentence of additional CJM Jorhat in CR case number so and so, before an appeal before the Court of Session Judge Jorhat, being criminal appeal number so and so. After hearing the learned session judge, after hearing the counsel at length, was pleased to admit the appeal for hearing, stay the operation of the impugned judgment, and sentence passed by so and so till disposal of the appeal. And secondly, your lordship, once an appeal is pending, it is the continuation of the trial. This has been informed to the in the appeal, and he requested for. So thereafter, your lordship, lordship will kindly take up annexure 9, page 49. This is the order of the appellate. Page 49, dated 8th December 2014.
This is 48. Page 48, annexure 9.
48, sorry, 48.
Yes, we have read this.
So this only line that has been given is that
We have read this.
so his termination is irrevocable. I have given some more letters, and in all the letters, and the I think there was a legal notice was also given, and all this they have just stated that it is irrevocable and therefore cannot. Now, your lordship will kindly take up the affidavit filed by the respondents. Here I will go to page para 9. I'm reading this, I'll complete. page 7 of the affidavit, para 9. That with regard to the statements made in para 8 of the writ petition, the deponent states that the Honorable Court of Additional Chief Judicial Magistrate Jorhat passed an order imposing 6-month imprisonment and a fine of 10,000 in default, 3 months simple imprisonment. Apart from this sentence, the accused was directed to pay compensation of 2 lakhs to the complainant. After the order by the
You're reading paragraph?
paragraph 9, at page 7 of the affidavit. The affidavit filed by the respondent.
Paragraph 9.
I'll read just 2 paragraphs of this.
Mm. Please read.
That with regard to the statements made in paragraph 8 of the writ petition, your deponent states that the Honorable Court of Additional Chief Judicial Magistrate Jorhat on so and so passed an order imposing 6 months of imprisonment and a fine of 20,000 in default, 3 months simple imprisonment. Apart from this, the sentence to the accused to direct a payment of 2 lakhs to the company. After the order passed by the learned Additional Chief Judicial Magistrate Jorhat, petitioner was suspended from service to the association with effect from so and so for violation of clause. There are 4 clauses. As the petitioner was arrested and imprisoned in Jorhat jail as per the order of the learned judicial magistrate. Thereafter, the petitioner was dismissed from service with effect from 4/9/2014 under clause so and so of the TRA rules. The authority lost the confidence of the petitioner as on several occasions petitioner was warned as well as lowered in rank from so and so to so and so. The relevant portion of clause so and so of TRA rules are quoted herein below. 7.1 Integrity. All employees should maintain honesty, live within the means of his or her income, and do not indulge in dishonest practice. 2. Devotion of duty. All employees will render faithful service to the TRA as assigned to him or from time to time. 7.3 Misconduct. The following acts and omissions on the part of the employee shall amount to misconduct. That is 7.3.2 Infidelity, theft, fraud, or dishonesty in connection with association's property or of any other person's property within the premises of the association. So these are the and 7.3.9 here it is not applicable, sleeping on duty. And the last one, that is 7.3.41 conviction by any court of law of any offense involving moral turpitude. So these basically, I think it is 7.3.2 and 7.3.4.41. These are the 2 grounds on which the employee he was dismissed. Then an employee found on investigation to be guilty of misconduct. 7.4.12 here. That is also important. That is there. An employee found on investigation.
Mr. Manan, what is this meaning at page 8, top paragraph? Please read the first part of the, as the petitioner was arrested for an imprisonment in Jorhat jail.
Yes.
As per so and so. Thereafter, the petitioner was dismissed
From service with
service
effect
and so
from
and so.
4/9.
Then thereafter, authority lost their confidence on the petitioner on several occasions.
Yes.
What is this? Petitioner was warned as well as lowered in rank from AD1.
This was, I'm just coming to that. This is also an X. I'll come to that anyway. There was earlier proceedings. That was an inquiry procedure. The inquiry was held and the petitioner was lowered in rank, one rank. That was from AD1-3 to AD1-2. That was earlier. There was one incident where an inquiry was held and then the petitioner was lowered in. That was an earlier case. Not with this matter. This matter basically with regard to the 2 checks and the conviction of the.
No, that we have understood, but this was one of the factors that even on earlier occasions.
Yeah, this was one of the factors, but whether if this is a factor, whether 2 things will come up, whether an inquiry is required or not. First and foremost, first question will be whether an inquiry is required or not. When you are terminating a service of a person, there is required. Earlier there was an inquiry, nothing to say on that. Here this time they are not having any inquiry. Conviction on the court. If the conviction of the court is the issue, then that is why I am coming in. If that is the issue, and then there has to be, these clauses has to be fulfilled. These 3-4 clauses which they have given, that has to be fulfilled. And the final clause that there is the decision that there has to be a conviction by a court of law, which involves moral turpitude. Now that is where I'm hitting your lordship, because 138 of NI Act does not involve moral turpitude. It is a civil. I'll just give the judgment. It's a civil wrong in the form of a criminal proceeding. So this is one. And secondly, your lordship will come to page 9, para 8.
Page 9.
Here also there was one thing, 7.4.12. I did not read. An employee found on investigation to be guilty of misconduct shall be liable to the following penalty. So there has to be some kind of investigation. I don't know what is the investigation here, because no investigation, no inquiry. 2 days. On 15, 16, there nothing was given. 17, he was terminated. Para 11, page 9. That your deponent denies the statement made in para 10, 11, and 12 of the writ petition and states that the question of holding a departmental enquiry does not arise, as the petitioner was convicted for a period of 6 months with fine of so and so. The petitioner was also directed to pay compensation of so and so. No notice is necessary before dismissing a person from service if he has been convicted by court. So this is the only ground on which he was dismissed. This is there in para 11. So earlier they said something, but this is the ground which they are saying that yes, we don't need notice, nothing is required because you were dismissing because you are convicted by the court. The disciplinary authority came to a conclusion that the petitioner's conduct was such that required his dismissal. In the instant case, these are, again, he's coming back to so many other things, but his main ground was with regard to the conviction.
Yes.
Now, your lordship, I'll just take your lordship to the fact. Lordship, I'll just hand over the clauses which has been referred. Take on the clauses which were referred were 7.1 that your lordship has seen, then 7.2, then 7.3.2, and 7.3.2 I just pointed out, if there is a theft, infidelity or dishonesty also, that should be within the association's property or by any person within the premises of the association. Here it is somebody else. I have taken loan from somebody else and there is a case with regard to that. Then your lordship, another 3.41. This is where the whole issue, conviction by any court of law of offense involving moral turpitude. So basically this is the case. Two points. One is that no inquiry. Second is moral turpitude. Now, if there is no moral turpitude, then there has to be an end. This is where I'll hand over a few judgment. I rely on a few judgments. Now, the first judgment that it's in a seriatim I've given that. This is a specifically exactly similar case, so I've given it in the first instance. That is, it's the High Court of Kerala, no doubt, but this was of 1995. The first line that says an interesting question, whether the offense under section 138 of Negotiable Instrument Act would involve moral turpitude. So here, your lordship, the court ultimately came to a finding that I have to- Para 6. We are of the view, this is a division bench judgment. I am coming to other judgments, similar judgment. We are the view that an offense under section 138 of the Act need not necessarily take the wings of offense of cheating as defined as section 415 of the Indian Penal
You're reading paragraph
Paragraph 6.
6. Yes.
We are the view that an offense under section 138 of the Act need not necessarily take wings of the offense of cheating as defined under section 415 of the Indian Penal Code. The cause of action of a criminal prosecution under section 138 of the Act will not arise, not on the date of issuance of the check, but only when the drawer of the check fails to pay the amount within the statutory period after he is being called upon by the paid for a note. The person sometimes may issue a check knowing that there is no sufficient fund in his account, but still with the hope that he would be able to make arrangements with the bankers to honor the check as and when it is presented by the drawer. Section 138 is in fact incorporated in the NI Act only to give more credibility for checks and not to cover the areas which are already within the jurisdiction of criminal code for the offense of cheating. So the question whether the act of issuing a check without sufficient fund will involve moral turpitude has to be considered because the element of cheating. So moral turpitude has not been defined in the statute. I am not reading that. Then, Your Lordship, para 10. Paragraph 10, the last few lines here. At this stage, we may say, at the fifth line from the para 10. At this stage, we may say that prior to the insertion of section 138 of the Act, issuance of check without sufficient funds not made an offense unless it falls under section 415 of the as an act of issuing a check without sufficient fund was not generally regarded moral wrong or corrupt. We are fortified in our view that the offense under section 138 will not normally involve moral turpitude. So the court found this is not involve moral turpitude. Then there are discussions of some other cases. And then para 12, we approve the said principle and hold that the question whether an offense could involve moral turpitude has to be decided on facts of each case. All offenses do not necessarily involve moral turpitude. Section 138 of the Act is no exception. The said principle on the facts of the case find no scope for holding that the offense found against the appellant has any reflection of turpitude. Then, Your Lordship, there's another judgment of the next judgment. This is Mangilal versus State of Rajasthan. This was a 2018 judgment. It was this was delivered in 2023. Recent judgment. Here, Your Lordship, I'll come to para 4. Para 4. The learned counsel vehemently argued that as a matter of fact, the respondents could not have dismissed the petitioner from services on the basis of conviction under section 138 of NI Act, as the dispute was otherwise a dispute of civil nature. It was argued that merely because a punishment has been prescribed for dishonor of check under section 138 of NI Act and the petitioner has been convicted, it cannot be said that his action or conduct has amounted to moral turpitude. Then, Your Lordship, will come to para 9. Para 9. That it is true that the petitioner was convicted under section 138 of the NI Act by judgment and order dated so and so. But this court is of firm view that a conviction under section 138 of the NI Act neither constitute a gross misconduct nor does it amount to moral turpitude. So, as to warrant disciplinary proceeding in the present factual backdrop, neither it has any nexus with the petitioner's employment nor the petitioner's negligence or financial constraints can be treated to be unbecoming of a government servant. By no stretch of imagination, the petitioner can be held unsuitable for public. Then, your lordship, it refers to the judgment of the Honorable Supreme Court in Mohan Raj, which says that moral turpitude is a civil wrong. It has clearly stated that it is quoted, in fact, it was quoted that your lordship will find that para 12. In fact, in 11, it says it's a civil dispute, and then quoting para 12, Mohan Raj versus Shah Brothers reported in 2021 6 SSC 258. I'm not bringing that judgment also because it is quoted here in this case itself. Therefore, your lordship will find para 45 and 53 of the said judgment of the Honorable Supreme Court was quoted here. Where it says that it is a civil liability. I'm not reading everything. Then in para 13 also, your lordship, this judgment I have brought this judgment also, but it is already reported here. In para 13, your lordship will see judgment of Honorable Supreme Court in the case of Kaushalya Devi Masan versus Rup Kishore Khore, reported in 2011 4 SCC 593. While expressing its opinion on the nature of offense under 138 Act, the court succinctly stated, para 11, having considered the submission made on behalf of parties, we are of the view that the gravity of complaint on Negotiable Instrument Act cannot be equated with an offense under the provisions of IPC or other criminal offense. An offense under section 138 of Negotiable Instrument Act is almost in civil nature of civil wrong, which has given criminal overtones. Para 14. In the opinion of this court, invoking provisions of Article 311 of the Constitution of India or Rule 19 of the rules, in event of conviction under Section 138 of NI Act is non-application of mind, if not arbitrary exercise of power. Then to a person's reputation or social stigma attached to a person's life by being dismissed from service is much more than what could have been the conviction of imprisonment consequent to dishonor of state. Such then is, as a matter of fact, a toll to the lives of the employee and his family. Para 15. Admittedly, no disciplinary proceedings have been initiated against the petitioner, though he was placed under suspension and has been expelled from employment solely because he failed to honor his financial commitment. I'll not read the quotations of Article 311. Para 18. It is to be noted that Article 311 2A also rules so and so, which is couched in similar words, speak of conduct which has led to a conviction on criminal charge. As has been opined above, a conviction under Section 138 of the NI Act is not a strict sensu conviction on criminal charge, given by a virtue of provisions of Section 140 of the NI Act, 143. An offense under an act is tried summarily by virtue of which has been provided in Section 262 to 265 of the Code of Criminal Procedure, under which procedure framing of charge is not mandatory. Again, the para 19, again the expression used in Article so and so is conduct which has led to. The conduct of an employee in the present case cannot be equated to conduct which otherwise leads to conviction on criminal charge, as is in the case of offense under Indian Penal Code or Prevention of Corruption Corruption Act. Until the Supreme Court, in the case of so and so versus so and so, 1985 to SCC, expressed opinion upon power of employers under Section 311 of the Constitution, and in case of dismiss, it took dismissed and thus held. So it stated Clause A of the second proviso to Section 311 of the Constitution confers on the government the power to dismiss a person from service on the ground of conduct which has led to the conviction on a criminal charge. But that power, like every other power, has to be exercised fairly, justly, and reasonably. The Constitution does not contemplate that a government servant who is convicted for parking his scooter in no parking area could be dismissed from service. He may perhaps not be entitled to be heard on the question of penalty, since Clause A of the second proviso so and so makes the provision of that. article applicable when a penalty is to be imposed on a government servant on the ground of conduct, which has led to his conviction on a criminal charge. But the right to impose a penalty carries with it the duty to act justly. In the instant case, the government chose to dismiss the appellant in a huff without applying its mind to the penalty which could appropriately be imposed on him in so far as his service career was concerned. Considering the fact of the case, there can be no two opinions that penalty of dismissal from service imposed upon an appellant is whimsical. Then your lordship, para 22, next page. To conclude, bearing in mind the nature of offense involved, which is predominantly civil, and the offense being not being the one against the society or public at large, coupled with the fact that the complainant himself has compromised the matter with the petition, this court is of the considered opinion that petitioner's dismissal in the present is liable to be set aside, and the petitioner has attained the age of superannuation pension, therefore the relief is mortal death. So what has happened? This case is basically similar to this matter. Here also it was convicted under 138 and no inquiry was held. Whimsically he was dismissed. Similar matter, this was on the, they have stated that there was moral turpitude, but the court all throughout stated that it is not no moral turpitude because it's civil wrong under 138. Then there is another judgment of the Kerala High Court, the next one that I have provided. Similar type, your lordship, similar matter, basically, para space 6, para 8. The conviction for the offense on the section 138 of the negotiable instrument has to be differentiated from the offenses. The offense on the section 138 of the negotiable instrument act is in fact technical offense in the sense on account of certain contingency. If the check has to be dishonored, the drawer of this check is liable to be punished under. If the conviction is for the sole reason that the check happened to be dishonored for want of sufficient funds, it does not involve moral turpitude. One may become poorer after issuance of the check. The offense under section 138 of negotiable instrument act cannot be classified, one coming under annexes so of TCS rules classified types. Now your lordship, in para 9, again, considering the facts and circumstances, it cannot be said that such a breach of to honor check would entail in an offense of moral turpitude.
Okay, this.
Then again, Kaushalla Devi has been considered, that is 2011 4 SCC 593 in para 9. It quoted that it cannot be equated. So basically the same thing, your lordship. Here also the check bounced, and so matter penalty was imposed, which cannot be imposed by the court has held that it cannot be. These two judgments on the basis of same fact, that only on the ground of bounce of check, the petitioner was given major penalty. Here in this case, only one thing the court said, that cannot give major penalty, but some minor penalty can be issued. That is the only difference that it has been stated in para 11, last part. Major penalty cannot be imposed, only a minor penalty can be. So this is the only difference in this. But here, your lordship, what has happened? Here there was an inquiry. In our case, there was no inquiry. So the previous case is more, your lordship, similar to this. Judgment. Then your lordship will kindly take up the Kaushalla Devi Masan judgment I have given. That is the reported, your lordship. I have given the judgment. The next judgment that is annexed, I'm not reading the judgment because that is not so much required. The Kaushalla Devi Masan versus Roop Kishore Khare. This is a 2011 judgment.
The paragraphs.
Here, your lordship, paragraph 9. That is quoted by all the other earlier judgments also.
Okay.
Then your lordship. There is another judgment. This is the 2022 judgment. Take a move, mark for- Okay, mark it for- Then 11 to- okay. Kita mo ikuy pa tumikikit na. Kita judgment क्यों दिया? Kita अलग-अलग judgment kita क्यों दिया? नहीं udah दिया tuh. Ini gimana nih? Kita pun tetap. 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 Itu pun tuh judgment Omendro Kumar Patel. Director. Paragraph. Itu.
On what point you want to show the other judgment?
Actually, the judgment that has been given are from Manupat.
No, no,
The learned friend actually took it out.
nothing,
And
for what
actually-
purpose? What is the point? Lord?
Basically, these two points.
That you have made
That
it
and
clear.
one more point is that enquiry has to be held in such case. Basically, there has to be an enquiry in case of dismissal.
Yes, madam.
My lord, it is admitted that no inquiry was conducted by this admitted fact. Prior to this, my lord, dismissal order, there are certain allegations against the prisoner, and those were, my lord, thoroughly inquired into, and court, the authority has come to a conclusion that prisoner is entitled for dismissal. He is not fit for rebut. Lenient view has been taken, and his rank was reduced, my lord. Lordship may kindly go through the, my lord, paragraph 5,
Of?
my affidavit. Page 4.
Just a minute. Yes.
The statement made in paragraph 3 of the petition are matter of record of the case. Your deponent does not admit any of the statements made which are contrary to and inconsistent with appears from record of the case. In this connection, deponent further states that the petitioner had indulged himself in many illegal activities in past, such as the petitioner number 1. The petitioner participated in unlawful assembly and other illegal activities in the office campus, leading to illegal confinement of the acting director and administrative officer of TRA on 10/12/1999, for which a charge sheet was issued to the petitioner on 14/12/1999. Subsequently, a warning letter was issued on demand to the petitioner for his illegal activity. Number 2, on 24/11/2009, a written complaint was received from Anil Phukon, Sinamara, regarding his forgery and money laundering cases. 3, the petitioner took money from Sri Miganko Hazarika of Rajabari, Jorhat, assuming him to give a job at TRA in the name of the Director of Administrative Officer. The complaint was made to the Director on demand on 6/1/2013 against the petitioner by the administrative officer. Again, another complaint was received against the petitioner from the administrative controller TRA on demand for his illegal activities, forgery and money laundering. 4,
A warning letter was issued to the petitioner on 23/4/2013 for his absence from duty without permission on sanction of leave and to involve himself with money laundering matters with private individuals. A complaint was received from Srimati Raju Choikia, Durhat, on 13/6/13 against the petitioner for taking 25,000 from her with an assurance to provide a job at
Okay, we'll come back. We'll come back. See, these matters which you have now trying to harp, those are not reflected in the dismissal order of 39, at page 39.
suspension order reflects.
No, suspension is not, nothing to do.
Reflects and
No, the dismissal order is the subject matter of challenge, page 39, 17 October. You found guilty, therefore you are out.
he is a man not fit. He is
You could have,
He is not clean man, my
you could have
lord.
initiated a fresh inquiry. Inquiry into the
the
charges.
inquiry is required, my lord. When
No,
there is-
you framed definite charges.
Yes.
You just cannot, and had it been a conviction on moral turpitude, matter would have been different. You need not hold a full-fledged inquiry. You can just, you have noticed that you are, have been found guilty under the charge of some rape or murder or something, which involves moral turpitude. Why should not be dismissed? Matter ends there. Only to clarify the factual position. Maybe it's not a factual, but that he was not convicted. Only to ascertain that. But here NIA Act conviction and page 39 does not even reflect. And you cannot take into consideration. You have to frame definite charges.
Yes.
And those earlier allegations, you took some action.
Yeah, that action has been.
You have
taken. That
taken
is-
action.
that is
Earlier
the-
order,
and in
earlier.
fact,
Warnings were given. We'll come back at 2. Maybe other matters will not be able to take up. Court is not well today. This matter will complete.
May be taken up on 5th floor.
Not on 5th, on 6th.
Sixth.
6th.
Deeply.
I have a similar prayer also, item number 7. May kindly fix another paper.
What is the urgency?
Lordship, my post has not been incorporated in the service code. This has been going on because my earlier.
We'll have some date, 6th of September. Okay. Yes, madam. Come.
My lord, item number,
Others, he'll give dates, don't worry. Yes.
Lordship. Lordship, may kindly go to the annexer P, page 20,
20
20.
of your affidavit in opposition. Yes.
This reference order that is so and so suspended you from the service of the association with effect from 4th.
Yes.
This is the dismissal order, my lord,
Yes.
17th October.
Yes.
This was, my lord, done because earlier several occasions he has been warned. And
Now, how does it reflect? Where does it reflect?
suspension order reflects, my lord, but this order does not reflect that for that earlier.
The
reason.
suspension was only for he being in custody for 48 hours.
Yes. More
That's a
than
different
48 hours.
matter. More than 40 hours. But this does not reflect anything. Other than the aspect of his conviction in a 138 proceeding.
Yes. My lord, his warning letters may kindly page 21, annex E, lordship will sign his back, my lord, service career record. He's not good, my lord. He's not a clean man, my lord. He's not fit to be kept.
Now, you have the means. How do you tackle with this?
My lord. One more thing is there, my lord, the appointment letter also, lordship, if lordship goes to the appointment letter, my lord, here also in clause 3,
Page
12,
of the affidavit in opposition.
affidavit question. The appointing authority has the right to terminate a person, my lord.
Page?
Page 12.
Yes.
Your service may be terminated at any time by giving 1 calendar month's notice in writing or at a discretion of the director by paying you 1 month's pay in lieu of the notice. Should you wish to leave the service, this is also, there is a right, my
This-
lord.
This is appointment as what?
Appointment as his,
Cleaner boy. Cleaner boy.
yes,
He's not been removed from cleaner boy. And even if you remove, you have the right to remove without, but did you follow the procedure of 3? Did you give him 1 month's notice?
that,
This is not applicable. This would be applicable in his initial period of service when he was inducted as a cleaner boy. Thereafter, what Mr. Manan has submitted, 86 he was cleaner boy, 2006 he was promoted. He may, we are not saying, commenting on his conduct, how he had conducted himself as a employee. But for that you have the measures. We could have taken up, you could have framed definite charges, proceed against him. That has not been done.
done, my lord.
And 138, involvement of moral turpitude is difficult to accept.
This warning letters may once drafted by court.
Page,
Page 21, 22,
warning letters of which year?
What's this?
13,
Warning letters of,
25 January 2000.
these are earlier
this
events.
conduct is not good, my lord. Earlier conduct is,
You should have, you have not even held an inquiry. You should have,
Yes.
could have held an inquiry.
so I pray, my lord, Rossum may remand back the matter.
Why
to-
should we remand back? We are not remanding
He
back.
is, this person will be retiring on 31st of
We are not remanding back. It's your prerogative. You have not done. Remanding for what?
For an inquiry, giving him an opportunity.
That is your prerogative. You have not done. Why should we advise you?
There was an inquiry against him and thereafter, my lord, the order of the inquiry, my lord, within 13 December 2013,
Where? Page
page 50,
50.
an exact case.
Yes.
Last paragraph, lord.
Hmm.
You have been found guilty of misconduct under so and so TR service code, and charges leveled and proof against you being grave and serious, warranting major penalty amounting to dismissal from service. However, management, while taking a lenient view, has decided to impose upon you the penalty under service rule so and so. You are lowered to 81 from for a period of 2 years with immediate effect. Instead of my dismissal, a lenient view was taken. A detailed inquiry was conducted. Inquiry report I have also annexed.
the order. I have also annexed.
This decision will be reviewed after 2 years, and if your conduct is found satisfactory, you may again be restored to your present position. While doing so, the management would like to warn you to desist from such activities as stated in this charge sheet. He has been warned on several occasions. Procedure, of course, not followed. That I
You follow the procedure. If he's a man with such antecedents, you frame definite charge. There, in that case, you have taken a lenient view. You said that it's a matter where you should be dismissed. In paragraph, page 50, the last paragraph, warranting major penalty amounting to dismissal from service. But still then, if you come to, if you turn over the page 51, 51, you say
Management
that how the management, while taking a lenient view, you could have taken these into consideration, let him know. Okay. Reserve put it. No. Y.S. Mannan, P. Burman, huh? Reserve. We'll reserve this, but we'll, could have dictated here, but may require some time.
Then one point that's I not bad was the appellate authorities. That was absolutely cryptic or nothing was given. They cannot, it is reconsidered. That's only one line. They have not considered. The judgments are there where your lordship, if your lordship, I can produce the judgments also. Otherwise, also that the appellate authority is a quasi judicial authority. The orders have to have some reasoning in.
Okay.
In fact, one of the judgment that I have produced, the last one, it has been stated that there has to be reasoning authority. And the second part is that no inquiry was held. Inquiry must be held. That is a recent judgment. I think it has come up about 10-15 days back. The last judgment that I have given. That is the judgment
We'll consider.
of Supreme Court of Sandeep. So, then edit. It is judgment. We will take any question. It has the court. Twen- 24 the code of
Okay. Oh. I see.